Yeah, we are now live.
Good morning, everybody. This is the meeting for the Blue Ribbon Commission of California, and the meeting is going to be called to order now. And I would request, please, if Ms. Wong could request or call roll, please.
Great. Yes. Thank you, Justice Guerrero. Susan Bakshian,
Present.
David Boyd,
Yes, I'm here.
Alex Chen, Ona Dosimu, Charles Duncan,
Present.
Jackie Gardina,
Here.
Ryan Harrison,
Present.
James Henderson,
Present.
Esther Lynn,
Here.
Tracy Montes,
Present.
Joshua Pertula, Judge Glenn Reeser,
I am here.
Natalie Rodriguez, Kristen Rossi,
Here.
Emily Scivoletto, I'm sorry, excuse me, sir. Emily Scivoletto,
I'm here.
Karen Silverman,
Here.
Mylene Spencer,
I'm here.
and Amy Williams.
Present.
We have a quorum, Justice Guerrero.
Thank you very much. On behalf of myself and the Vice Chair, Josh Bertola, I want to thank all of the commission members and also the bar staff who helped put this meeting together. And I appreciate all of your hard work. It really is an honor to be the chair of this commission as we embark on the important work of making recommendations about how best to ensure that all of the California entry-level attorneys represent their clients competently and ethically, and also that we adopt a process that is fair and equitable to all applicants. We do have a busy agenda that has been distributed in advance, as well as materials for your review. Primarily, the objective today will be to look at and review work that has been done previously, including various studies, and to obtain reports from prior work in order to help frame our discussions and to assist us with our future decision making and evaluation. During this meeting, as well as during all of our meetings, I do wish that it was in person, but by now probably many of us are accustomed to Zoom meetings. I look forward to meeting you in person. Until then, this is the format that I'm hopeful will work as well and be effective. I'm interested in hearing all of your viewpoints and carefully considering all of the diverse perspectives that you each bring on how to accomplish our objectives, as well as the comments from public members. Public comments have been submitted in advance, and we will review those carefully as well. I know that we won't always agree on various issues, but I would hope that each of us would strive to do our work with the common commitment that we each have to the directives of our charter, and also with respect and civility toward one another. I thought it would be helpful. Many of you may know each other. I know some of you, and I've reached out to some of the panelists. I thought it would be helpful if each of you could introduce yourselves and share a little bit about your background and anything else that you would like for the other commission members to know about your interest in the work of the Blue Ribbon Commission. And hopefully anyone that we miss, we can catch up with at a later point. I thought the easiest way to do it, I see all of your faces on the screen. I thought the most seamless way might be for me to call on you. And I apologize for calling on you, but I'm going to go ahead and use the roster that I have. So the individuals are grouped by various categories. And if I mispronounce your name, please correct me. And if someone's not here, then we'll move on to the next commission member. I have first on my list, Ona Dosimu. I'm not sure that she checked in.
I'm here.
Oh, good. Thank you.
Thank you. Good morning, everyone. My name is Ona Alston Dosimu. I am currently the CEO and Executive Director of the California Lawyers Association. I am absolutely thrilled to have been chosen to join this very, very impressive group of folks. I have a longstanding interest in education and particularly legal education, having served for 2 terms on my law school, Georgetown University Law Center Alumni Board, and been engaged in other efforts. And obviously, as someone who's engaged with CLA, at least for the immediate term, I have a real interest in the future of the profession. So pleased to be here and deeply grateful and look forward to hearing from and meeting all of you.
Thank you very much. Charles Duggan.
Hello, Justice, and hello, everyone. It's very good to meet you. My name is Charles Duggan. I am a first-year associate at the law offices of Bellis & Bellis, which by a mile is the least impressive title amongst the commission. But it's very good to meet all of you. It's a pleasure and a privilege to be here. I graduated from the Santa Clara Law in 2019 and passed the February 2020 bar, which had the lowest passage rate in the history of the California State Bar examination, approximately 28%. That was an intense and interesting experience, and I am aware of much more recent experience for me than for many other members of the commission who've been practicing for some time. So with that being said, I look forward to working with all of you and contributing in the fashion that I can.
Thank you very much. Amy Williams.
Good morning, everyone. This is Amy Williams. I apologize for my camera being off, but I am in the midst of a travel work trip for work. So I am in an undesirable location. My name is Amy, and I have been licensed in the state of California since 2003 and had a non-traditional, unconventional way to pursuing my law degree and passing the California bar exam, one of the hardest exams in the nation. And I was a corporate litigator for 10 years and hung up my hat and retired from corporate litigation and opened a marketing resource agency with my husband and partner. That's been successful for the last 10 years. We're a 7-figure business. And luckily, my corporate background has come in very, very handy. And now I'm mentoring other small businesses as well. I'm very happy to be a part of this commission because I think that as we pursue higher education, candidates need to know what they're getting into. And it is my opinion that when students are graduating from law school, they do not have the practical experience that they need in their first year of practicing law. And passing the bar exam, although one of the most important steps that you can take in pursuing your legal journey, it does not prepare you for the practice of law. And that's one of the things that I would like to change, that perception for incoming candidates. Thank you.
Thank you, Amy. Susan Bakshian.
It's Bakshian or Bakshian, either one.
Okay, thank you. Do you have a preference?
No, one is closer to English, one is closer to Farsi. Either will be great.
Thank you.
I am a professor at Loyola Law School. I'm also a California attorney. I am thrilled to be here as part of the commission because the bar exam has been part of my professional career for at least 2 decades. I took the California bar exam in 1991. So I took a very different exam, and I hope that this commission is going to be able to bring a very different exam to California.
Thank you. Maylin Spencer.
Good morning, everyone. And it's Mylin Spencer.
Mylin, thank you.
Sure.
Apologize.
I'm a clinical law professor at UC Hastings, and I'm thrilled to be here. Most relevantly, I teach a live client clinic, and I also teach evidence, which is a double-tested bar subject. So I have a strong interest in ensuring that the bar exam better prepare and better test ability to practice rather than ability to take a timed closed book exam.
Thank you. Natalie Rodriguez.
Hi, everyone. Nice to meet you. I am a professor of law at Southwestern Law School, as well as the Assistant Dean for Academic Success. I'm very interested in all things bar exam. I've had the opportunity to work on the performance study with the California State Bar, and then most recently on the Building a Better Bar, where I had the opportunity to listen from just a number of early attorneys, new attorneys, and what were the skills and knowledge they needed in those early years. And I am looking forward to, with this group, coming up with recommendations for a bar exam that better reflect what those applicants, or I'm sorry, what those attorneys were reporting they were doing in those first few years.
Thank you, Natalie. Alex Chan.
Morning, everyone. I'm Alex. I am a member of the California Bar Examiners, and I am a trial attorney by day. I know most of the folks here. I don't know what else to say other than I'm very familiar with the process, so hopefully I can contribute whatever I can to the benefits of this group.
Thank you, Alex. Esther Lynn.
Good morning, everyone. I'm Esther Lynn, and I currently serve as the chair of the Committee of Bar Examiners. And for my day job, I'm a deputy attorney in Orange County. I'm very honored to be here. I look forward to being a part of this commission because I do think there's a fine line between ensuring access to justice from both a public perspective as well as from an attorney applicant perspective. So thanks for having me.
Thank you. Jackie Gardina.
Good morning, Jackie Gardina. I am the Dean of the Santa Barbara and Ventura Colleges of Law, which is a California accredited law school. I came here about 5 years ago from a traditional ABA law school on the East Coast, where I practiced at a law firm in Boston and also was able to clerk at the trial and appellate level at the federal First Circuit and Massachusetts District Court. I come here as a CAPA member, so I was able to serve on the California Attorney Practice Analysis Working Group, and I'll be presenting along with Dr. Henderson and Judge Reeser on some of those recommendations. Like everyone else, I would like, I'm not going to call it a bar exam because I hope we're keeping an open mind and really think about it as a pathway to licensure, and for us to think innovatively about how we can best ensure that public protection along with access and opportunity and that access to legal services that so many Californians need. I look forward to it.
Thank you, Jackie. I'm going to need help with Emily, your last name, Skidoletto.
Perfect.
Okay, thank you.
Thanks, Justice. Yes, my name is Emily Skidoletto. I use she, her pronouns. I am the Senior Assistant Dean for Student Affairs at UC Davis Law School. I have also worked at 3 other California law schools, and I've been in legal education for about 17 years. I was also with Jackie on the CAPA working group and have taught both the bar prep class to law students at 4 law schools, and also I teach leadership in the law. So I'm very much looking forward to being a part of this, and thanks for having me.
Thank you, Emily. Ryan Harrison.
Good morning, everyone. I'm Ryan Harrison. I am the current vice chair of the Council on Access and Fairness and the rising chair, barring any surprises. Let's see, I started out as a law enforcement officer in the Senate Rules Committee, protecting the state senators, and I was inspired to do more just from experiencing what goes on in the legislature. So I earned my master's degree in criminal justice and later attended law school at UC Hastings, passed the bar. Now I'm a practicing attorney here at Jackson Lewis, where I provide labor and employment assistance for employers. I am very committed to inspiring young, diverse individuals to having an interest in the field of law and becoming attorneys. And I draw a connection between a belief among diverse people in society that this system of government, the system of justice works for them and understands their culture and their needs, and how that promotes positive citizenship behaviors among a broader range of people. There's a connection, in my opinion, to criminal deviance. Now with the bar exam, that's clearly a gateway for individuals to become among those arbiters of justice that we all currently are as lawyers and judges. And so I would like to definitely add some insight into this process, into the bar exam, make sure it tests all the skills that we need to have and show proficiency in order to become good attorneys. And I thank you very much, and I'm very proud to be here. I also am a former extern for the Chief Justice.
Thank you very much. Kristen Rossi.
Hi there, it's Rosie actually, but that's okay.
Rosie, no, thank you for correcting me.
No worries. Thank you, Justice. I'm Judge Kristen Rossi. I am the Chief Judge of the California Department of Insurance, and like Ryan, a member of COAF. I've been on the bench for about 13 years now. Before that, I worked as an attorney for the state. I also serve as the Vice President of the International Association of LGBTQ+ judges. And like Ryan, I am here because I want to ensure that that all diverse viewpoints are heard, and that we create a pathway to the legal profession that reflects the diversity of California, and therefore gains the trust of the population.
Thank you, Kristen. Judge Rosa. Judge Weister, I'm sorry. I had to flip the page. And
Good morning. I'm Judge Glenn Reeser.
Reeser, and I still got it wrong. Thank you.
It's not a problem. It's such a pleasure to be here. I feel very honored and privileged to be part of this committee. I was a litigation lawyer in a different century for more than 20 years. I was a judge for more than 20 years. I did a lot of, so as a judge, in addition to my assignments, I did a lot of work with the Judicial Council involved in court technology. I still am very involved in judicial education, even though I'm retired. I work with JAMS now, which is, as most of you know, is a co-op of retired judges and others. I don't have any set agenda. I'm a big proponent of diversity and inclusion. I'm a big proponent of access to justice. I'm not certain we need a bar exam, and I'm not certain we need a bar exam that looks like what people are currently undertaking. So I'm here with an open mind. I was a CAPA member. I thought I had an open mind with CAPA, and I continue to do so. And I look forward to working with all of you and all of your diverse views.
Thank you very much. David Boyd.
Good morning. I'm Dave Boyd. I practiced law in Alabama for many, many years. I'm a litigator. I'm former chair of the Alabama Board of Bar Examiners. I'm a longtime volunteer with the National Conference of Bar Examiners. I chaired that board about 15 years ago. I continue to serve as a volunteer on committees. I'm former chair of the Multistate Bar Examination Policy Committee, and I was a member of the NCBE Testing Task Force that has just completed its work recently. And I too look forward to the opportunity to participate, and very interested in going forward. Thank you for including me.
Thank you very much. Dr. Henderson, James Henderson.
Thank you. I'm Jim Henderson. Thank you very much. And I am a psychometrician, so I'm not an attorney, one of the few people in the meeting who does not practice law, never has. A psychometrician, in case that's a term that is new to you, is a profession that focuses on the research that supports the development and use of different kinds of assessments. In my case, I specialize in licensure and certification testing, and it was a privilege over a 1.5 year long span of time to work with Ron P. and the CAPA task force, and look forward to sharing with you in a little bit some of the findings from that study, along with Jackie and Glenn. Thank you very much. I'm really pleased to be part of the commission.
Thank you. Tracy Montes.
Good morning. I'm Tracy Montez, and I'm also a psychometrician and not an attorney. And I'm very honored to be part of this commission. I am the Division Chief of Programs and Policy Review with the California Department of Consumer Affairs. And I grew up here. I have about 25 years of experience developing regulatory examinations. Prior to DCA, I did do selection exams for fire service and law enforcement. So I'm really all about testing. I thoroughly enjoy it. I think there's a lot of misinformation about exams and what their purpose is. And so I like to educate individuals about testing and really reinforce that there's a specific purpose and intent, and it's about being fair, balancing consumer protection with providing opportunities to practice in the field of interest. So I'm very excited to be part of this commission, and thank you very much.
Thank you, Tracy. I'm not sure if Josh is in a position to speak, but I don't want to pass him up either. We'll just maybe give him a minute if he wants to weigh in. Okay, we'll go ahead and catch up with him later. And next is Karen Silverman.
Good morning.
Hi.
Delighted and honored to be here. Justice, good to see you again.
You too.
Which sort of takes me to my biography. For 30 years, I was a practicing attorney in and out of the government and corporate law, most recently 20 years at Latham, where I was doing competition law. But I recently, and the reason I'm here is actually my new focus is on primarily business consulting and a little bit of law around frontier technologies and the responsible use and governance of those technologies, and working with enterprises, including the state bar, on how to deploy those technologies in responsible and effective ways. So I'm very much interested in learning and have a very open mind about what the future of the bar may look like, but I think it's very interconnected with a whole suite of issues in ed tech and sort of the related functionalities. So I'm here to really help provide context and insight around the technology piece of this. And it's a pleasure to see some familiar faces and meet everyone I don't already know.
Thank you, Karen. And I am Patricia Guerrero. I'm on the Court of Appeal now, and I've been here. It's surprising that it's gone by this fast. I've been here since December 2017. Before that, I was with the Superior Court in San Diego, and before I was on the Court of Appeal, I did a variety of things, but before I was on the Court of Appeal, I was a supervising judge in family court, so a much different pace from where I am now. Before that, I was primarily at Latham and Watkins, and so I'm familiar, and it's nice to have Karen as part of this commission in both of our San Diego and San Francisco offices, doing primarily environmental litigation. And also I was at the U.S. Attorney's Office as a federal prosecutor. I grew up in the Imperial Valley, where I didn't know any attorneys growing up, and I definitely am interested in ensuring access to justice and also the protection of the public through whatever we end up developing. And I also am open to all of your viewpoints and various ideas on how to ensure that we make recommendations that will be helpful to the Supreme Court. So I really am excited about this opportunity and working with all of you. It's clear from your introductions and going through your bios that we received that the commission members really do reflect our state's demographic and geographic diversity, and also diversity in terms of various practice areas. I think that will definitely suit us well. I think we're at the time now for introductions to conclude, and the next item on the agenda will be a review of our commission charter and also a decision tree that we have sort of developed for a visual of our directives. So I think at this point, there might be some sharing of the screen for the decision tree. I'm not sure if someone's going to do that or if we should start with the charter, which you should all have. So I'm not sure we need to share that portion of it, but if not, then I'll just go through it. I don't want to read through verbatim the charter, but you should all have received it. I just wanted to highlight some of the different topics or key areas. One of the themes is it starts with our purpose, and part of it includes a review of the work which many of you participated in or are otherwise familiar with the California Attorney Practice Analysis Working Group. And we'll hear more about it later, but they were tasked with better understanding the knowledge, the skills, and abilities that are needed for specifically entry-level attorneys in California. And also a couple of things, the tasks that they do, as well as the knowledge that they need to perform those tasks. So I look forward to hearing the presentation later in more detail about that. They then created a blueprint and identified various topics. There were 8 topics that they identified for a bar exam and question items, as well as 6 different skill sets that they concluded were most likely to be the ones that were necessary, again, for entry-level attorneys. So our purpose is to review some of that work, as well as the work that has been ongoing with the National Conference of Bar Examiners and CBE, and their task to determine the content and the format of the uniform bar exam. So the charter directs us to evaluate the recommendations that were raised by the CAPA working group, and also to be more open and to evaluate various additional policy questions regarding, I'll use bar exam for now because that's in the charter, although I am sensitive to the comments that were made earlier that we should be looking at this maybe with that as an open question as to whether it should be a bar exam. But I'll use the terminology of the charter. We're asked to review that, as well as the pass score that was recently lowered in California. So again, reviewing the CAPA recommendations and the format and pass score for the California bar examination. We're to look at changes that may be made, and also additional or alternative. So that's directly in the charter as well. Alternative testing or tools. And the objective is to, as was reflected in your introductions, to ensure minimum competence in the practice of the law. So again, in the charter section, there's various items to review: the CAPA working group's recommendations, the results of the 2020 National NCBE analysis and recommendations for the uniform bar examination, and other recent studies. Many of those were in the library that was submitted. Although there's so much written, I'm sure that there will be other areas that we identify in other studies that we'd want to take a closer look at as well. There's specifically mentioned in here, which I'm happy to see, data examining the pass rates of applicants of color specifically. And just scanning through here. The objective again is restated to ensure that attorneys are prepared to practice the law ethically and competently at a level appropriate for entry-level attorneys.
I can share the decision tree if you'd like me to.
Okay, thank you. I'm not sure if you all can see that, but you should also have received it. And this is sort of a visual of different decision points that we really need to focus on here. There are different categories. The circles are the content of a potential bar exam, the type of questions to ask, and also the format. And this is designed to depict whether there's some similarity in areas of difference with the California bar exam and also the uniform bar exam. So the threshold questions that we need to ask are whether California should adopt the uniform bar examination or to retain the California bar exam for purposes of determining minimum competency for the practice of law. And then there's questions that we need to ask depending on what path we're recommending. We have to determine as part of this task whether there's sufficient alignment in the knowledge, skills, and abilities that are to be tested on the uniform bar exam with those that were identified through the CAPA working group as the skill set for California. So the areas of similarity in this decision tree are marked with the legend that's green to show that they're similar. So in the first bubble, scope of legal knowledge and skills and the content of the exam, those areas were similar in California and also what we expect for the uniform bar examination. Where it's to be evaluated further in terms of similarities or dissimilarities is the relative weights. And we'll hear again more about this later, but there were different opinions as to what should be given more weight in terms of these areas. If we conclude that there's not sufficient alignment with the uniform bar examination's future direction, then the decision tree shows implementation of CAPA recommendations on subject matters for the California bar examination. And again, this is just one possibility, but sort of depicting the possible paths if the choices are the uniform bar examination versus the CAPA working group's recommendations. If there is sufficient alignment, then we also need to consider the type of questions that are asked. And then again, the decision tree highlights the areas in green where there's similarity in terms of various question types, the selected response or multiple choice questions, the constructed response or the essay and performance test questions, and then the areas that are to be evaluated are other item considerations. There's been discussion of whether to have an open book evaluation process or various computer adaptations, and we'll hear more about that in one of the presentations as well. And again, if there is insufficient alignment, then the decision tree moves down to the same assessing and evaluating CAPA's recommendations. If there is sufficient alignment, then another area that we would have to consider is the specific testing format, whether it's computer-based, which is the direction of the uniform bar examination, or not. And so again, these are questions that need to be evaluated, and other considerations that are highlighted in the category below in the sort of diagram section on the right-hand side. Is the bar exam the correct tool? Again, the threshold question, whether it is the direct tool to determine minimum competency to practice, and also the pass score specifically, consideration of the temporary provisional licensing program that California recently adopted, testing of supplemental content if we do adopt a California model, or even if we adopt the uniform bar examination, whether there should be additional components, including supplemental material that is necessary for an attorney to practice in California. And again, as mentioned in the charter, the pass rate of applicants of color is another policy issue for the commission to consider. So I think that's all for the decision tree. And there also is a category on the agenda. I wasn't sure what housekeeping items, if there are any housekeeping items at this time.
No, I think we can proceed to public comment.
Okay, thank you, Amy. As noted in our agenda for today's meeting, the public was given an opportunity to comment. We do have a limited period of time allotted for public comment. Members of the public who wish to comment were encouraged to submit their comments in writing prior to our meeting to ensure that the members would have an opportunity to consider those comments in advance. And we did receive several comments, and I wanted to thank the members of the public for their submissions. We also will have an opportunity now for public comments. I wanted to go over some of the logistics first. We're going to attempt to call members of the public in the order that they appeared or submitted their request. There will be a limit of 2 minutes per public comment, so we ask that you limit your comments accordingly. And to help the commission to consider your viewpoints, we do ask that you, the best way to utilize your time is not to repeat what other members or other speakers have previously stated. The total time period is going to be 15 minutes so that we can move on and also consider other items on the agenda. The logistics for the Zoom meeting are as follows. That you should have a little hand so that you have the ability to raise your hand. It's an icon of a hand. It should appear on the bottom center of your screen. And you should click on that if you wish to make a public comment. And for any members of the public who are participating by phone and wish to comment, you can do that by pressing *9. Again, the star key followed by the number 9. And we'll call the members of the public in the order that they identify themselves through the raised hands, and then also enable the microphones of the specific speakers individually, one at a time. So I'll ask Kim if you could please call the speakers in the order that they appear.
Sure. I will call on those who have raised your hand and that you would like to give a public comment. When your name is called, you will be given 2 minutes to make your comment. I will indicate when your time, 30 seconds left. If you can please wrap up your comments then within your allotted time. So you may begin right now. I see the caller ID, user ID 1. You may begin your comment now. Caller in user 1. Can you unmute your
Hello?
mic? Yes, hi.
Hi, thank you. My comment is regarding the pricing scheme of the bar exam. I hope that that is kept in mind with all these discussions. Currently, California has one of the highest costs for the bar exam, and for some unknown reason have penalized folks with out-of-state licenses with a higher, even higher cost. I had the audacity to get an out-of-state license as a Plan B, and I'm signed up for this next bar exam and had to pay an additional $300 for no apparent reason. And Also, the reports on the actual cost of the last few bar exams that have been remote. I know that I've sat in on some calls where your staff member, Tammy, went over the actual cost of the bar exam in October and in February, and it ranged about $350 per applicant, and I am paying $1,150. So I'd like to know where that money's going, and I'd like to see some accountability. And I know I've heard Ms. Herskowitz make comments that there were some unforeseen costs with having people view videos that were flagged, et cetera, and that wasn't calculated in the 350 range. Well, that's not a good enough response. It's not acceptable. We as the public should be able to see the full cost of this exam and the last several exams, and refunds should be made. And there should be some justification provided for why, as an out-of-state attorney, I'm a California resident with an out-of-state license, why I have to pay an additional amount. Now, fresh out of school, $850 is a pretty steep price. And I'm really hoping that California can come in line with the rest of the country. Thank you, I'm done.
Thank you for your comment. The next, I will call Benjamin Cohn. Mr. Cohn, go ahead.
Hello, my name is Benjamin Cohn. I'm an attorney recently licensed in California, before that licensed in Iowa. My comment today is in regards to the event style of twice a year specific dates component of the exam. I believe that there should be some consideration given to how other professions do licensing exams and other high stakes standardized tests are done, where exams can still be scheduled for particular appointments that don't have all people testing at once. This would give a lot more flexibility in how preparations for exams are done, how exams are scheduled around other life commitments, as well as give people the opportunity to retake closer to the benefits of the studying they'd already done, or after slight delays or last minute emergencies come up, without waiting 6 months for something that will take another 6 months to grade, and all the career implications that go with it. I know Xtegrity exam software had also expressed that part of the technological challenges with remote exams have been this event style method, and that it would be a lot easier to securely administer and flexibly administer exams if they could be scheduled more flexibly. I think that that is also a consideration. Beyond that, there's currently reports that there's huge standard deviations between different readers' grading of the exam, and that might also be looked into, how to get a little bit more objectivity in the grading rubric of the exam. And finally, if it's within the purview of the commission, I do think the admissions rules should be,
can you please wrap up your comments?
Yes, should be reviewed for where they might be creating disparate impacts, both among races, racial pass rate, disparate income, as well as potentially other disparate impacts, including for applicants with disabilities, and whether the admissions rules may be playing a role in that procedurally. So those are my comments. Thank you.
Thank you, Mr. Cohn. At the moment, Justice Guerrero, I don't see any hands raised. I think this is the, we conclude the public comments period.
Thank you. The public comments will be considered, both the ones that were submitted in writing as well as the two that we received now. And thank you very much for your comments. We appreciate that. At this point, we're going to begin the first presentation. which will discuss what the current bar exam looks like today. And we'll have a discussion of the format of the exam, how it's developed and graded, and a discussion also of the pass rates and other statistics. This presentation will be with Amy Nunez and Ron P. Amy is the director of the Office of Admissions with the California State Bar. I'm sure all of you, or many of you, know her, as well as Ron P., the principal analyst with the State Bar, who I have heard described as the State Bar's data guru. So we're happy to have both of you presenting.
All right, thank you, Justice. I'm Amy Nunez, and I will be presenting, as the Justice has described, a context, history, and a description of the California Bar Exam and its administration. And my co-presenter, Ron B. From the Office of Research and Institutional Accountability, will highlight applicant profiles, specifically who's taking the exam by race, ethnicity, gender, school type, as well as pass rates trending over the past 20 years. Next slide, please. So to begin with, it's very critical to distinguish how California differs from other bar jurisdictions in the country. Next slide, please. The legal education required to be eligible to sit for the bar exam differs from other jurisdictions in that California provides multiple educational pathways. As noted here, one can attain a JD from an American Bar Association or California accredited law school, or have obtained 4 years of law study from an unaccredited law school, or through the law office study program, or a distance learning program. Foreign educated students possessing a first degree in law qualify to sit for the bar exam, as well as attorneys admitted in other states or countries where appropriate documentation confirms that they were admitted in that jurisdiction. California has 52 law schools in the states, while other states have far fewer. Of the 52 law schools in California, 18 are ABA approved, 18 are California accredited, and 16 are registered or unaccredited law schools. Most other states have between 1 and 3 ABA approved law schools. There are 15 other states and the District of Columbia that have 4 or more ABA law schools, with New York having the second most in the nation at 15. There are 4 other states that also recognize alternative law schools that are not ABA approved, and that includes Alabama, Connecticut, Massachusetts, and Tennessee. 3 other states also allow law office study programs, as California does, and they include Vermont, Virginia, and Washington. So to become licensed to practice in California, one must fulfill the following requirements. First, a positive moral character determination is a requirement to practice, and this includes a background check of fingerprints, DMV records, criminal background checks, and employment and personal reference checks. Applicants must also comply with Family Code Section 17520 and cannot have outstanding California court-ordered child or family support obligations. Applicants must also pass the Multistate Professional Responsibility Examination with a scaled score of 86 or higher, and they cannot have any outstanding unpaid fees to the California State Bar. Lastly, they must have passed the bar exam with the appropriate scaled score. The cut score now is 1390, and prior to the July 2020 exam, the cut score was 1440. Now, in January of this year, the California Supreme Court approved an exception in which allows some applicants entry as licensed attorney without having passed the California bar examination. These are applicants that have been provisionally licensed in California. And a quick background, in October of 2020, the Supreme Court approved California Rule of Court 9.49, which implemented the first provisional licensing program in California and went into effect in November. And what the program did is allow applicants that met the educational requirements, had minimally submitted a moral character application, and graduated law school between December 2019 and December 2020, the ability to practice under the supervision of a California licensed attorney, the ability to practice law in California. The California Supreme Court amended that rule in January of this year and expanded the eligibility of provisional licensing program. The expansion made it possible for bar exam applicants who achieved a total scaled score greater than 1390, the new cut score, either at first read or as a total scale score between July 2015 and February 2020. They allowed the ability to serve as a provisionally licensed attorney, and also these candidates would be eligible for full licensing after 300 hours of work as a PLL, and along with a positive referral from their supervisor in lieu of passing the bar exam. And that is that exception noted here in this slide. All right, so next slide, please. Okay, so this is a historical context that brings us to where the bar exam is today. So the first bar examinations in California were administered in 1919 by a board of bar examiners comprised of members appointed by the Supreme Court. That board was established 8 years before the state bar was created. So when the state bar came into existence in 1927, the Committee of Bar Examiners was established to carry out the admissions requirements. From 1932 until 1972, the California bar exam consisted of 20 essay questions, and applicants needed an average score of 70 of the highest possible grade to pass. In 1972, the Multistate Bar Exam, the MBE, a 200-item multiple choice test developed by the National Conference of Bar Examiners, was added to the bar exam. And that was given a weight of 30% of the total value of the exam, with the essay portion being 70%. The pass line combined for these, my screen just went out, remained at 70%. Prior to the adoption of the MBE, the number of essay questions was reduced from 20 to 12. For the exam, 12 essay questions were drawn from 3 sections of 5 questions each, and applicants were required to answer 4 of the 5 questions in each section and allotted over 52 minutes per question to complete their answers. In 1978, a number of additional changes were introduced to the bar exam. The first is the number of essay questions was reduced once more, this time from 12 to 9, but applicants were required to answer all of the questions. Also, the time allocated to answering questions was increased to a full hour per question. The weighting of the MBE and essay questions was also shifted. So the MBE accounted for 35% of the total scaled score, and the essay counted for 65%. In addition, during this period, a modification was made to the grading process, and this was the introduction of phase grading. And this was conducted in part to save time on the grading, but also to provide a second look to exams that fell within the range of 67.3% and 71%. So exams were graded initially by randomly selecting the responses from one essay test session for 3 questions, grading these and then evaluating the applicant score in conjunction with the applicant score on the MBE. If that score was high enough to virtually assure that they would pass, if all their answers were read, then the applicant was admitted to the bar without grading the remaining essays. 1 second, please. All right. If, however, the randomly selected essays did not appear to guarantee a passing score, then all of the remaining questions were graded to determine if the applicant passed. In 1981, a bifurcation rule was implemented, which allowed applicants to repeat only one part of the exam if they failed overall, but passed one portion. Although applicants were able to bifurcate the results as late as July 1985, this practice was discontinued because it was found to actually decrease rather than increase pass rates. In 1984, the practice of sampling the 3 essay exams also discontinued because it was determined that the labor savings of reading only a sample of a small proportion of the total exams had a negligible impact on the cost of administering the exam. In 1983, a performance test section was added to the bar exam. While this initially included a multiple choice section and scoring separate from both the MBE and the essay portion of the exam, By 1985, the multiple choice portion of the performance test was eliminated. And by 1987, the essay and performance test questions were combined into a single written score. In February 1985, the CBE recommended that the essay and performance test portions of the bar exam be scaled to the MBE. Scaling the written portions of the exam to the MBE was a procedure that was used by many states and recommended by many testing experts. Scaling the examination in this manner ensured that variations in the level of difficulty of the examination did not produce fluctuations in the pass rate from one exam cycle to the next. We're going to hear more about scaling at the next presentation. In July 1985, the CBE adopted in principle the scaling of the essay and performance test portions to the MBE. However, because the scoring was changing, a new pass line had to be determined. Next slide, please. So at its April 1986 meeting, the Board of Trustees approved the committee's request to begin scaling the examination, effective with the February 1987 administration of the bar exam. The Board of Trustees also set the passing score to be equivalent to the mean difficulty index before reappraisal from the last 10 spring and fall bar examinations. And that score was determined to be a total scaled score of 1440. In 2017, after significant psychometric analysis, the California bar exam was changed from a 3-day exam to a 2-day. Some of the goals around that change included a reduction in exam cost and expediting the grading process while maintaining consistent reliability of the exam. In 2017, the California State Bar also embarked on a few significant studies, including the content validation study and the standard setting analysis. These studies informed the CBE, the Board of Trustees, and the Supreme Court to change the cut score. Starting with July 2020, the Supreme Court changed the cut score from 1440 to 1390. Next slide, please. This is a map of the uniform bar exam examination across jurisdictions. The map details the number of states currently using the MBE, which are highlighted in orange. The UBE contains 3 components. There's a 200 multiple choice section, the MBE, that's used in California. There's an MEE, the multi-state essay examination portion, which includes 6 essay questions. And lastly, the last component of the UBE is the multi-state performance test, which includes 2 performance tasks. Currently, only 12 states, including California, and 3 US territories do not use MBE. And by July 2020, Pennsylvania will also be implementing the UBE. All jurisdictions in US territories currently utilize the MPRE. Next slide, please. So the bar exam is a 2-day exam. Day 1 consists of 5 one-hour essay questions and a 90-minute performance test. Performance test questions are designed to be completed in 90 minutes and test an applicant's ability to handle a select number of legal authorities in the context of a factual problem involving a client. A PT question consists of 2 separate sets of materials, a file and a library with instructions advising the applicant on the tasks to be performed. Day 2 of the bar exam involves 200 multiple choice items, and they're organized in 4 90-minute sessions. This is an exam developed by the National Conference of Bar Examiners, and this is the one portion of the UBE that California utilizes. Next slide, please. These are the 13 subjects that are currently tested on the bar exam. All right, next slide. So, as for how the exam items are developed, the written portion of the California bar exam is developed as follows. For the essay questions, the examinations department solicits questions annually, or more often depending on the needs of the various subject matter question banks, from various law professors and other qualified drafters around the country. Staff work with the examination development and grading, which stands for EDG, the EDGE team for exam development and grading of the exam after each administration. The essay questions are pre-tested before any administration on the exam, and thereafter selected questions are nominated and edited by the EDGE team under the supervision of the program manager for examinations for each bar exam. The EDGE team is comprised of 6 active California attorneys who have expertise in 13 subjects, the 13 subjects tested on the bar exam and in the grading of exam answers in those subject areas. The members of the EDGE team are hired from the ranks of the most senior California bar exam graders and all have vast grading experience. They're retained on a staggered basis and under contract. For the performance test items, the examinations department works with 4 members of the performance test drafting team, all of whom are clinical law professors, legal practitioners, and or academics inside and outside of California. An EDGE team member selected on a rotating basis also participates in each performance test drafting team meeting. Performance tests are drafted 2 times a year, after which the entire PT drafting team meets to edit under the supervision of the program manager. Again, all performance test questions are pre-tested after initial drafting, editing, and thereafter undergo further editing as informed by pre-test results. The members of the PT drafting team are also retained on an annual basis. The question development, so that's drafting, editing, pre-testing, is continuous throughout each year for both the essay questions and performance test items. This ensures that there is a constant bank of questions to draw from for each administration of the bar exam. The EDGE team and attorney members of the CBE meet twice a year to finalize a selection of the questions that will appear on the February and July administrations of the California bar exam. All right, next slide, please. As for the exam administrations, so exam administration happens twice a year. For the in-person administration, examinations can be taken on a laptop or in writing on site, and security is of utmost importance. We use proctors at each testing location as part of that security assurance. And also there are strict regulations about what an applicant can bring to that exam site. Next slide, please. So in terms of our exam sites, testing facilities, the number vary for the February and July administration. And the state bar uses between 10 and 12 facilities across the state, contingent on the volume of applicants registered for the exam. With July having the highest number of applicants testing, we use approximately 12 sites. We have standard testing sites and sites dedicated for applicants with testing accommodations. The state bar complies with the ADA by providing accommodations for applicants with a demonstrated need for them. Next slide, please. This has a few pop-ups. For the remote administration, the examination, again, can be also be taken in laptop or in writing. And one caveat is for those needing to write, they need to test in person, as currently there is no secure method for delivering a paper exam. As with the in-person exam, security is of utmost importance. The state bar relies on a combination of artificial intelligence and human proctors for monitoring the remote examination. As with the in-person version of the exam, there are strict regulations about what an applicant can have with them during the examination. A remote examination does not eliminate the need for in-person administrations. I already mentioned there's applicants who choose to handwrite the exam need to do that in person. Also, those with insufficient testing space available to them, perhaps a lack of internet, a lack of just basic space, are also granted the ability to test in person, and as well as testing accommodations that are not compatible with remote testing. They can also test in person. The state bar uses facilities during the remote administration and still require proctors, security, staff, and resources in the field. Next slide, please. Now, for bar exam grading, the key elements in grading are anonymity, organization, and consistency. All essays use code numbers and contain no corresponding identifying information about the applicant. For examinees taking the exam online, the State Bar receives electronic files of their essays, and hard copy essays are scanned into the case management system, and these files are what's shared with the graders. As for the graders, the State Bar maintains a diverse pool of approximately 150 experienced attorneys. Efforts are made to achieve diversity in age, race, ethnicity, geography, and backgrounds. A majority of graders have been grading bar exams for at least 5 years, and many of them have participated for well over 10 years. 6 groups, each consisting of experienced graders and up to 4 apprentice graders, are selected to grade the essays and PT answers. The groups convene 3 times early in the grading cycle for the purposes of calibration, and a member of the EDGE team supervises each of the groups of graders. There are 2 phases of grading. At first read, any applicant receiving a total scaled score of 1390 and above passed the exam. Anyone achieving a total scaled score that within a 50-point range, that is between 1350 and 1389.9, proceed to second read. At second read, all essays are read by a second grader. If the applicant's average total scaled score after the 2 readings are 1390 or higher, the applicant passes the exam. And examinees with a total scale score of 1350 or below, whether at first read or second read, fail the exam. Next slide, please. On occasion, the Office of Admissions is asked why it takes so long to grade the exam. The February bar exam takes approximately 10 weeks to grade, while the July bar exam takes approximately 14 weeks to grade. And essentially, there are a few reasons, starting with the preparing of the files for the graders, that is ensuring that they're complete and organized electronically. The phased grading approach also impacts the schedule. Graders and staff need sufficient time to complete calibration and to proceed with the first and second reads. And as you can see here, the volume of applicants also impact. We have an average of 9,500 applicants for the July exam and 5,500 for the February. When you multiply that with the number of answers that are required to be reviewed, gives you a sense of the amount of time that needs to be spent dedicated to the grading process. All right, and with that, I'm now going to hand it over to Ron B.
Morning, everyone. My name is Ron B. As Amy noted, what I put together is for purpose of presenting an overview of the bar exam applicants over the past 20 years, based on demographics and school type and some other factors. And when I looked at the 20-year period, the data, it's convenient to divide it into 2 10-year periods. So the following slides, I'll be going over the changes in the trends over time, divided into 2 time periods, as well as across the different subgroups based on the factors in terms of demographics and school type. So the first slide shows, on the left-hand side is a table of the average number of bar exam takers over the 2 10-year periods. You can see pretty stable figures within the category of February exams and July and October exams. So February exam in general, you'd see about 5,000 exam takers. And for the July exam takers, it reaches more than 8,000 on average, close to 9,000. And as far as first time and repeater is concerned, it's almost the inverse between the February and the July. In February exams, you have close to 70% of the exam takers are repeaters, and 30% for July. Overall, in a year is about 45%. So the chart shows over time, the repeaters, with all of the fluctuations the past few years, the repeaters as a proportion of total exam takers had increased, and first-time takers going the other direction from 2013 has declined a little bit. And in 2019, the repeaters, the number of repeaters exceeded the first-time takers. Next, please. And because the difference in a lot of the background characteristics between first-time repeaters, the following slides, I limit the analysis to first-time takers only to make the comparability across the different cohorts over time a little easier to draw conclusions. So this graphic shows the changes in the proportion of exam takers over time, first-time takers. In terms of their race and ethnicity background, I grouped them into whites versus non-whites, and gender, female as a proportion of the total, and school type, just in terms of whether they came from ABA graduates, California ABA or others. The first one about non-white, beginning of the period, they account for 30% of the total exam takers the first time. By the end of the period, they exceeded 50%. This is probably also a small percentage of them because of the changes in demographic information the past 2 to 3 years, allowing for selection of more than one. So we have a slight increase of the multiracial category that's not previously available in the data collection format. Now, female exam takers has a clear upward trend from 2015. And at the end of the period, total percentage exceeded, obviously 50%, it reached 55%. The trend for California ABA fluctuated over time, and by the end of the period, they accounted for less than 50% of the total. Next, please. A comparison of race, ethnicity, and gender across school type between the two time periods. First is non-whites represent close to 45% of applicants from out-of-state ABAs and other law schools in the past 10 years. It's a little slightly higher than the percentage in California law schools. Across all school types, non-white applicants increased by more than 20% between the two 10-year periods. And female applicants in California ABA law schools exceeded 50% in both time periods. That's a very different kind of a distribution compared to other school types. Next. Aside from race, ethnicity, and gender, if you compare the characteristics of the applicants across school types, the biggest difference actually is in the age cohorts. And the graph shows what's called a histogram. It's the distribution of age from the youngest in late 20s all the way to a small percentage. Every exam has someone in late 70, very old applicants. And if you look at the comparison of the age cohorts in the table on the right-hand side, you can see that more than 80% of ADA law school students are under the age of 30, compared to California non-ABA law schools, less than 30% of them. You could also see the difference by looking at the median age. California ABA is about 27 years old, and California non-ABA is close to 10 years older. Next, please. Looking at the school type and age that in the other chart showing a histogram distribution, This is the percentage distribution across both dimensions. So on the horizontal, the percentage shows the number of first-time applicants across school type. So you can see California ABA represents, on the basis of the horizontal axis, close to or a little over 50% came from California ABA. With California non-ABA accounts for about 10%, the remaining from out-of-state ABA and other law schools. The others mainly are attorney applicants and foreign law school students. On the horizontal is distribution of age across within each of the school type. So you can see the patterns are very different, and the percentage within each box represent the percent in relation to the total number of applicants. You can see 28% of California ABA is between the age of 26 and 30. That's the largest percentage across all of the groups. Next, please. After looking at the profile in terms of all of these characteristics over the past 20 years, the next question is, how are the patterns, the pass rate have changed over time and across the different subgroups that we looked at? So the first thing is also on the basis of the exams in July versus February for those first time and repeat takers. Here again, we see very different clustering of the pass rate. Each dot, each circle on the graph represents one particular exam. And the clustering together just shows how closely they are related. The highest cluster in the pass rate you can see is first time July exam takers. And the lowest is the repeat takers in July. This is partly the result of each exam. If you fail, then you register for the next one. So the July exam repeat takers, they came from February first-time takers largely. Of course, there are some that's repeated over time. So these are the four distinct groups that we have to keep in mind when we compare the patterns of pass rate over time. Even though they are very different, over the years, the fluctuations stay within a 20 percentage points for each group. And similar to the previous comparison, I limited it to first-time exam takers. The following comparison of pass rate, I limited it to all of those first-time takers. Next, please. In the same way as the previous chart showing the clustering of different exams, and this is the trend over time, and you can see clearly the different rates over time, even though the fluctuation over time shows similar patterns, especially between those in July and those in February. So over time, first-time takers in July achieved the highest pass rate of 78% in 2008, which was repeated almost to the same level last year, reaching a 73% pass rate for the first-time July takers. The repeat takers achieved their highest pass rate at 43% in July last year. Next, please. From here is a comparison across school types over time, limited to first-time takers in July. You can see the close pass rates between California and out-of-state ABA. And at the bottom of the overall trend is California non-ABA law schools. And the difference across the school types also remained fairly stable. The difference between, for example, ABA and non-ABA applicants, the gap is about 40 to 50%. Next, please. Not only is there a difference across school types over time is fairly stable, if you look at within each school type, their pass rate, you can see the fluctuations year to year is more stable for California ABA and out-of-state ABA relative to California non-ABA schools. And the box just shows the range of the pass rates. And that box represents the middle 50% of the pass rate within each school type. So the larger box for California non-ABA and other law school types represents the greater fluctuation in their year-to-year pass rate performance. Next, please. Similar trend instead of across school type. This is comparison by race, ethnicity, and gender. I grouped them into 4 categories: white female, white male, non-white female, and non-white male. And over time, again, you see the whites, whether female or male, their performance in pass rate is almost the same trend. And this a similar kind of a pattern for non-white between female and male over time. Among first-time July takers, there's hardly any difference across all of the times. The gap in pass rate between white and non-white is also fairly stable over the years, is around 15 percentage points. Next, please. In the same way that I evaluated fluctuations with their performance year to year, changes in the pass rate across school type, this is comparison of the stability of performance within each of the race, ethnicity, and gender groups. Here, among the 4 groups, white male, non-white male, and non-white female, they stay within the same range of fluctuation over time. The only exception is non-white male. They seem to have a greater change year to year in the pass rate. So this is all the high-level broad stroke comparison of the profile and their bar exam pass rate performance over the past 20 years. Any questions from here?
Thank you both. There appear to be no questions, but we'll give another opportunity. Does anyone have questions? Neil?
Yeah, thanks Amy and Ron for that presentation. That was a lot of really important detail. I had a question, and I guess maybe I'm directing this question to Amy, I suppose, because it relates to your part of the presentation. Can you tell us why bifurcation ended in 1984? You know, the allowing folks to repeat those parts of the exam that they may have failed, as opposed to having them take the whole test again.
Why the decision was made to do that, or to end that?
Why the decision was made to end bifurcation?
So the bifurcation intent was to increase the pass rate, potentially to allow someone just to take the portions of the exam that they had missed. And in the long run, what was discovered is that it actually negatively impacted the pass rate. People were taking that portion of the exam and still not passing. So in that 4-year period that bifurcation existed, the end result was to cease with that practice, because it did not do what it was intended to do, which is to increase the pass rate.
Okay, thanks, Amy.
Mm-hmm.
Thank you, Neil. And I neglected to introduce you earlier. I wasn't sure if you wanted to be introduced with the commission members. The principal attorney for the Chief Justice probably doesn't need any introductions, but if you wanted to say something, this is your opportunity.
No, thanks, Justice Guerrero. But yeah, I mean, the commission members have seen my name come up before. I'm just very ecstatic that this group is together and getting this work underway. I know it's going to be tough, but I'm so excited. I wish I could peek ahead to November 2022 and see what this group comes with. But we've got a lot to do and a lot to consider. So I'm very happy to get this process started.
Thank you, Neil. Yes, I'm sure all of us wish that we had a crystal ball here, but we'll have to patiently go through the process to figure that out. Those were wonderful presentations, a lot of information, as Neil indicated, and I'm hopeful that we can distribute the materials of PowerPoint presentations. I think would be helpful, and some of us absorb more if we have the written materials, and so I'll ask if that could be done afterwards. That would be great. Are there any more questions from anyone? It looks like there aren't any questions, and we can circle back if there are any at the end. Also, I think this is scheduled time for one of our breaks. We're pretty much on track. So we'll just end this a little bit early and take a 10-minute break at this point and reconvene at 11:36. Thank you. Okay, we're back in session. It's 11:36 and it looks like everybody is joining or in the process of joining. I'm going to introduce the next topic, which will be a discussion by Roger Bolas regarding the relationship between the MBE, the multi-state bar examination, and California's bar exam. And as has been mentioned, there's a component that does include the 200 multiple choice questions. And Roger will provide a little bit of background as to why that's part of the California bar examination. Mr. Bolas?
Can I have, am I able to share my screen at this point?
I believe you should be able to do that.
Okay, great. Okay, my name is Dr. Roger Bolus, and I have been a consulting psychometrician to the state bar since the early 80s. So I have been around for most of the changes that have occurred over time, been involved in a lot of the research that led to the policy changes. And I could, before I begin, I can praise California for its data-driven decisions in terms of making policy changes. A lot of the states I work with, which numbered over 25 over the years, haven't taken this amount of rigor in terms of making policy changes. And I actually will allude to one at the end of my presentation and indicate what kind of problems that they got into. So I've been asked to talk about the MBE and the role that it plays. And I think to explain that role, I'd like to expand it just a little bit so that you have a broader context as to why the MBE was been included in the examination process. I'd like to talk a minute about the standards for licensing and credentialing examinations. It's kind of the Bible that guides most of the examination decisions. Some of the considerations for test construction and the California bar exam. Then I'd like to focus in on multiple choice tests in general and the MBE specifically, looking at both its strengths and weaknesses. And I understand California, just like a lot of other states, are looking at what might occur if the MBE was eliminated. So I'd like to discuss some of the potential impacts and then finish off with experiences from a couple states that I work with or have worked with about some of the issues they have had with the MBE. So the standards for educational psychological testing was first published in '54 and is now in its 7th edition. It's been jointly developed and maintained by the major measurement agencies in the country, the societies, American Psychological Association, the American Educational Research Association, National Council on Measurement and Education. And it is the de facto authority for high stakes licensing and other credentialing programs. Now, the standards document itself contains over 300 very specific standards, ranging all the way from test development through use and all the way to evaluation. And the strength of the document is that it is based in current measurement theory as well as applied testing practices. So this is just not some theoretical document that's been in place. So while there are over 300 specific standards, they do tend to fall into 4 domain areas. And I put a scale in here because it kind of reflects the fact that these need to be balanced in any testing program. The first cornerstone, which is probably the most important and the one that the public seems to be most concerned about, is validity, which basically asks the question, does the test measure what it's supposed to measure? Are we talking here, is our bar exam actually measuring minimal competency to practice? Reliability, which is addresses the question, are the scores that result from a test stable and consistent? One of the issues that we always face is being able to avert to a group of people that if I took the test today, I could and needed to take the test again in another 6 months, I should be coming up with basically the same score and the same decision made. If not, the technical quality of the examination would be called into question. Fairness, which is another major concern of the public, is asking whether the instrument or the test or the assessment is along with its method of delivery, the content within it, the scoring and everything else, does that test unfairly disadvantage specific subgroups? It's a very key aspect of the standards that evidence be prepared for any test that it is not doing that. And from the practical standpoint, we look at the standards and ask the question, are the testing costs appropriate? You heard that one person call in today, and you know that these are concerns. And is test takers' time used efficiently? If you think about it, you could be testing for 2 weeks and have a very, very accurate assessment of where that person stands. But the question is that an efficient use of either the testing agency's time or the test taker's time? And the answer is obviously no. So these 4 cornerstones often come into conflict in an actual testing program, and the issue is to be extremely considerate of all of these and have thoughtful discussions about how they can be balanced. Now, I may repeat some of the things that Amy and Ron mentioned, but I thought it was worth it since you're now embarking on potentially restructuring the examination, is to just be aware of all of the decisions that need to go into a test design. We talk about test formats. You know, what kind of test sections should be involved? Should there be a single format or multiple formats? How much time should be dedicated to testing? If there are multiple sections on an examination, should some sections be given more time or less time based on perceived importance? Once you're within a section, how many questions should be in a section? How do you go about constructing questions? You heard Amy walk through what happens with the essay portion of the examination, and the current process has been honed by well over 30 years of going through the process and effectively documenting it. Administration and security, concerns around that based on the recent change in administration brought on by the pandemic and moving to a online test versus local testing, grading practices, scoring rules and point assignments. How do we weight the sections? How do we set a passing score? Effectively making passing decisions, and score banking and retaking the decisions. So again, Amy discussed some of this, but I thought it was worth maybe repeating a little bit. We now know we have 3 sections on the test. We used to have 1 back in pre-80s before I was involved with it, and now we're at 3 hours or 3 tests. We recently were able to, through research, reduce the time of testing from 3 days and 15 hours down to 12.5 hours. Again, without sacrificing reliability and improving the cost effectiveness and efficiency, and thereby meeting some of the cornerstones of these standards. You can see how we've allocated out time for responding to the sessions. We now are down to 5 essays and 1 PT, reducing the exam by a PT and an essay. The question construction process you heard from Amy, using the development team and their process, and multiple choice test, or the MBE, is developed by the National Conference of Bar Examiners. They have a very well documented process in place. The National Conference grades their multiple choice. I'll talk a minute or two about this notion of equating and why it's important in the process that they followed. And Amy discussed the California's approach. When our graders are grading the essay and performance task, they're using a 40 to 100 point scale. That is not a true 40 to 100 point scale because they are graded in 5-point implements, which enters into some of the considerations as to why those are subsequently adjusted. The national conference creates a raw score from the MBE, but then subsequently goes through a process called equating, and I'll talk about that in a second. And then what California subsequently does is scales its raw score, its written score, which is inclusive of the essay and PT, and places it on the same scale of measurement as the MBE. As Ron was presenting all of the results of comparing scores and passing rates over time, the primary reason why he could do that from a psychometric standpoint is that the California's total scale score has basically meant the same thing from the early 80s to present. Somebody achieving a score of 125 or 130 on the California exam on 1 year has approximately the same ability levels as somebody achieving that in the subsequent year. And that is absolutely critical for ensuring comparability of scores over time. The sections are weighted 50%, and through the scaling process, that weighting process is not only nominal, basically saying we're going to weight it 50%, but mathematically we are ensured that each of those scores will contribute to the total score at 50% each. We talked about the passing score. We talked about the concept of banking, which was basically allowing if you passed one portion of the exam and not another, you being able to store that and only taking one section. That was allowable many, many years ago, but our research showed that indeed it did not increase the passing rate and actually hindered performance, because we have what we call a compensatory exam, which actually allows consideration of both sections in terms of allocating the scores. And we have basically an unlimited number of retakes. So as we focus more on the multi-state, these are basically what the objectives are of the multi-state as expressed by the national conference. First, to assess the extent to which an examinee can apply fundamental legal principles and legal reasoning to analyze a given fact pattern. So it's to apply principles and reasoning to a given fact pattern. There's some degree of memorization involved in that, but the concept or the construct it's getting at here is the notion of applying, or an application, which is a slightly higher learning skill on the hierarchy of learning. And to focus on the understanding of legal principles rather than memorization of local case or statutory law. Okay. So what does the MBE consist of? It is 200 multiple choice questions, but only 175 of those are actually scored. On any given exam, the national conference will include 25 experimental questions. They may appear once or twice, depending on how good the question has been performing. There's 4 response options per question, but one of the unique aspects of the MBE is the fact that some number of items are repeated from one administration to the next administration. That number is not published, but best practice guidelines suggest that at least 20% of items get repeated for the purpose of equating. And I calculated that as being about 35 items. The test is administered in a single day, 2 3-hour sessions. And up until a few years ago, the test consisted of 6 subtest areas, but in February of 2015, civil procedures was added to the test. So there are pros and cons to a multiple choice format. The pros, one of the major advantages of a multiple choice format is that you can cover a wide range of material in a short period of time. The depth at which you can probe those areas depends on the structure of the test, how many questions are allocated to that particular area, but you can get in a significant number of questions. You could never imagine asking 175 essay questions in a single day. So you are able to assess broad areas. You can get different ranges of difficulty in those questions. You can generally test knowledge and some application skills. As I talked about the cons, you'll see what that limitation is. You can grade electronically. Grading doesn't take 8 to 10 weeks, which is a significant advantage, especially when you're trying to release scores quickly. Questions can be repeated over time. It's very, very difficult for any one person to memorize lots and lots of questions. And from a testing standards standpoint, you can obtain excellent reliability per unit of testing time, something that other forms of testing won't yield. Now, there are cons to it. Despite what people think, developing a good multiple choice question is extremely difficult. Ensuring that the stem of the question doesn't provide too many clues into what the answer would be, ensuring that the response options are provide you with enough of a interest that it may draw the applicant to potentially select it, and having them so that they're basically not trick answers. So it is difficult. You can't do issue spotting with a multiple choice question very easily. When you create a question, there has to be one right answer, and you can generally not test advanced analytic skills with a multiple choice question. It does not say that as a result of that it's not an effective question, but it only takes you so far in terms of what you can test. We know for sure that there are a lot of concern about the validity of the multi-state, in the sense that the common argument is that, well, we never have to take a multiple choice test when we're practicing the exam. We always have access to other forms of documentation to look up. So the whole idea of a closed book test is of concern. And the notion of being able to recover, actually that should be a pro, of the recovering questions if there is a security breach, just because of the volume of questions that are out there. So when we look at the MBE as a specific example of a multiple choice, with 175 items, we know we can get a broad sample of legal knowledge and application. The rigorousness of the NCBE's development processes is well known. There is specifically enhanced test security on such a large item bank, and we actually ran into some of this issue with the putting the test on an automated delivery platform during the pandemic. I was acutely involved with several states' issues around that. We also know that the scores aren't affected by subjective grading. The answer on one administration is going to be the answer on another administration. We don't have to worry about the difficulty of the items changing. We don't have to worry about examiners being more or less lenient when they're evaluating those questions. As I mentioned before, the scores are highly reliable. The reliability of the MBE anchors California's reliability. When we look at both the written portion and the MBE portion together, our exam clearly meets standards of reliability. And the primary reason for this is that the reliability of the MBE now approaches around 0.94, and that's out of an index of 1. Testing standards for a high stakes test require a reliability at a minimum of 0.88 and above, and so we're well within that. The primary reason I think primary value of the MBE is that through the process of equating, which starts with the idea of putting the same items on multiple exams and going through some advanced statistical processes called IRT, item response theory, that process results in ensuring that two individuals with the same ability level testing at different times would achieve roughly the same scale score. And along with that comes all of the advantages of being able to do that. The standard of fairness would dictate that I have the same opportunity to exhibit my ability levels over time, and that my performance should not be affected by the test that I'm given. So equating clearly responds back to this notion of fairness over administrations. Equating also ensures that two individuals with the same ability level tested at the same time with different versions of the examination would also achieve the same scale score. So perhaps the most primary, the most useful value of the MBE is the fact that it has been equated, and NCBE goes through the process of making that happen. The other value to the exam process in scoring is the fact that our written scores can be scaled to that written portion. And scaling basically adjusts the written portion of the exam to control for any differences that might crop up in the difficulty of the written questions and the greater leniency. So that implies that if one particular examination happens to have easier questions, despite all of the calibration that goes on and the processes that are in place to construct the questions, it's very easy when constructing a written examination that the difficulty of those questions can change. And furthermore, after even the rigorous calibration process that California goes through with its graders, there is leniency in changing, adjusting of standards. Scaling the examination basically eliminates the effect of both of those. The other residual from that, the process of scaling, is that when the written scores are on the same scale of measurement as the MBE, it's a well-known statistical fact that the weighting that we want to apply, in our case 50-50, carries through all the way to the final score. In the absence of having something on the same scale of measurement, you can assure that. It would be like trying to add centigrade temperature to a Fahrenheit temperature. You basically cannot add those two. When I look at this, consider what might be the weaknesses, and I put weaknesses in quotes because from a psychometric standpoint, the MBE offers a very, very strong test. But there are potentially weaknesses that I think are not inherent weaknesses, but it's just simply a reliance on the national conference's policy. First of all, as I think one of the callers said, it can only be administered twice a year on fixed dates. And the reason for that is not wanting to release all those items at different times during the years and the basic equating process that goes on in the background. The method of administration is determined by NCBE. If you recall, last October during the pandemic, NCBE was simply not going to carry out its normal scaling operations, and initially, and then over time, it softened a little bit, but that mode of administering in person versus an automated platform will become, I believe, more of an issue over time. The content coverage is determined by NCBE, although it is fed by a number of sources, but the content is definitely NCBE's. It's a fairly broad coverage, but again, the determination is ultimately made by the NCBE. The length of the test and number of items is determined by NCBE. When we were trying to make a determination last October, about what we were going to do in terms of handling a multiple choice test, and NCBE indicated that they would provide us with a 100-item test. We did some research to determine whether or not we may potentially lose a lot of reliability in our exam. And in our analysis indicated that even a 100-item exam yielded a fairly high level of reliability. So I'm not here to indicate that 175 items isn't enough, or 100 is too many, or 100 is not enough. But there are opportunities for modifying that. We know the training materials, what's released in terms of items, is shaped by NCBE, and the cost for the use of the NCBE is determined by, the MBE is determined by NCBE. So if you were to consider eliminating a multiple choice component, understand these would be some of the considerations that you would need to address. you would need to come up with a method of ensuring that you have comparability in scores year over year. And process alone modifications will not be able to do that. Will you need to substitute an alternative method, an alternative multiple choice test of your own making? California does do some of its own equating on its first year examination, so it's no stranger to doing that. You'd have to ensure that whatever scale scores come out of the exam, you have a strong understanding of what they mean, as opposed to just some theoretical scales. Since everything is now anchored against the MBE, a lot of research out there on that, and that provides a pretty strong foundation. You would need to ensure that you get the same level of historic reliability and you can meet those standards. And as you go, and believe it or not, as you go through question construction and grading rubrics and grading practices, they will change in the absence of having an anchor instrument. And I know that now from firsthand experience. Over the pandemic, Nevada, which has historically used the MBE to scale, and by the way, virtually every state scales the same exact way. They do scale their written section to the MBE. The people who are using the UBE and those not using the UBE do that. Nevada did decide to go without the MBE because of scheduling issues and the like. They couldn't true up their schedule with the national conference, and they based their scores solely on what the graders gave. They expanded the number of questions, but their graders, even though they graded every question twice, they ran into significant problems when they knew that they were looking at each question knowing that a quote 70 passed the exam. And in interviews with them, they realized they felt a lot of additional pressure, thinking that they were making a final determination, not on where an applicant would rank order, but whether or not the applicant was passing or failing. The other thing that they encountered was its wide variation in the difficulty levels of the questions. And the problems got to be so severe that I think after considering this for 2 years, Nevada will be going back to use of the MBE in this July. And whether or not they continue to do that is unknown at this point. Louisiana, which practices the Napoleonic Code, has never used an MBE, and they have been trying for over 15 years to construct their own multiple choice test, and they have learned how problematic and difficult it is, and have yet to put in a multiple choice test that they can scale to. That has led to several problems over the years in terms of addressing, again, the same problem that Nevada had, which is running into a particular easy question or a particular difficult question, or even having a grader or two applying a particularly difficult standard to the grading process. So those are real life problems that are out there or have occurred for states that have opted not to use a standardized assessment instrument. So take questions if you have any.
Yeah, I think Ryan had a question. Thank you very much, Dr. Bolus, for that helpful presentation. Ryan, if you still have a question.
Yes, I do. Thanks, Dr. Bolus. A few slides ago, you kept referring to two test takers with the same ability. They are able to essentially produce relatively the same score on the MBE, and that's why it's a reliable test. I'm curious to know.
No, I'm sorry, just to correct you there. That in and of itself doesn't ensure reliability.
Right.
It just it ensures fairness.
Yes. My question has to do with the word ability. What type of ability? Is it the ability to do well on the test, or are you testing other abilities? And if you could include in your answer some of the weaknesses that you covered for the MBE, which are it doesn't really test issue spotting that well, and it has limited testing of advanced analytical skills. So
right,
ability.
Right. So I guess I'm not here to support or criticize the content of the. I'm not questioning the content validity of the MBE. I think the MBE does an excellent job of getting to knowledge and application skills. So I would answer that by saying any two applicants who had the same level of knowledge and application skills would end up with the same scale score on the test. So whether or not if a multiple choice test could include other more advanced assessment skills such as evaluation or deep analysis or whatever, then the process of equating would ensure that people with that whole constellation of skills would end up with the same with the same scores.
Okay. Has anyone ever tried to develop a test that included, for like one fact pattern, both a written answer and a multiple choice section?
Well, I do know that the maybe not the same fact pattern because that would be more for an experimental purpose. And we actually did do some of that back in the early 80s where we presented during what we called the assessment center when we were experimenting with multiple testing methods. What was that? Almost 40 years ago. We did do some of that. We made an effort to put the same content into different formats, into video, into multiple choice, and into written assessments, just to determine whether or not we would see some correlation in the performance. And amazingly enough, we did see some fairly high levels of correlation, meaning that people who, they scored equally well on relative to other people on the different forms of assessment. And back in the day, now things have changed. Back in the day, that was kind of an argument for saying, well, should you go to the effort, again, looking at the cost effectiveness standard, should you go to the effort of making videos and ensuring that they've been edited correctly, et cetera, when you can get a pretty fair assessment, at least of some of the skills, through an alternative and more efficient method of testing. But again, as a con of the multiple choice format is you can't always get to those higher level skills by doing that.
Thank you.
Thank you. I don't want to cut off the questioning, but I also want to get to the next topic, but we do have, it looks like 2 questions. So I'll ask Emily first. Oh, actually we have quite a few. I'll ask in the order, first with Emily, then Natalie, then Neil, and then Alex.
Thank you, Justice. And thank you, Dr. Bolus. I just had a follow-up question to that, which is, do you have an opinion on whether or not using the multiple choice question format for a bar exam would be appropriate if we are not testing legal reasoning or legal principles. That is, if we are going to test, for example, whether or not an applicant can correctly determine whether or not facts relating to their client's case are a strength or a weakness, or some other type of skill that we have not necessarily tested before in the multiple choice arena? Or would you say that the multiple choice question format is really limited to the legal reasoning and legal principles?
You know, I wouldn't preclude considering a multiple choice format for that, but it would take some, I'm guessing, a lot of experimentation to get to that point. My concerns lie not only with that, but some of the other uses of the MBE, and that is assuming that you had some instrumentation that no longer included some sort of standardized assessment in which there was some replication over time in terms of the content that wouldn't jeopardize the security of the test. I would have some issues with how you would go about attacking that problem. I personally don't know. Maybe there's been advances since I've had to deal with this in terms of construction, but being in the trenches and having to do the scaling and whatever, I would have a hard time understanding how you could effectively doing that. I should mention to you that the correlation, which is, you know, the similarities in rank ordering applicants in the various sections of the exam, historically run around 0.7 to 0.75, which by social science standards is quite high. And basically what that is saying is that a multiple choice test that looks at potentially other content areas does tend to rank order people very similar to other forms of assessment, like the performance tasks or the essay, fairly well. Now, it's not perfect, and there are clearly people who do better on the multiple choice than on the essays. We do know that women perform better on the essays than on the multiple choice and vice versa. But considering the fact that when we're looking for fairness, part of fairness is ensuring that you've got multiple methods in there that speak to the strengths and weaknesses of the different subgroups of interest. So I wouldn't rule it out. I think it would be difficult, though.
Thank you. And Natalie?
Coming back to the strengths of the MBE slide where you talk about equating to measure that applicants are of the same ability, is that when they look at the LSAT, or what measure exactly is being applied to make that determination?
That's basically looking at the sum of their raw scores. So, and it's over time. So basically ensuring that somebody had over time with the same score would come out with basically the same ability level. So I test you in 2015. You and I have the same ability level. I get tested in 2020. The score that results, MBE score that would result from both of our tests should come out to be essentially the same. And the reason how that's done is by inserting the same core of questions in both of our tests. So you saw the same 35 questions that I did. You saw another 100. I'm just assuming it's 35. You saw another 140 different 140 than I did. But through the process of equating any differences in the difficulty levels of those unique questions can be accounted for through the equating process.
I guess my question was more about how do they determine that both you and I would be of the same ability?
Because we were given the same set of equators. It happens through the equating process. There's no, it's not like they're assuming that that we were given the exact same test. Because in theory, if we were given the exact same test, that test would measure your ability the same as it would measure my ability. And if theoretically we had the same ability, we should come out with the same score, correct? Or roughly the same score.
Okay, thank you. It sounds like this is an area that we'll continue to explore further. And Natalie, it looks like you may have a follow-up question, but okay, you don't. I'll move on to Neil and then to Alex.
Thanks, Dr. Bowles, for the presentation. So I'm going to sort of piggyback on some of the other questions previously asked. But I'm going to hit mainly on the con of limited ability to test analytical skills. Now,
I'm sorry, Neil, what did you say? The what?
The limited ability for multiple choice to be able to test analytical skills.
Yep.
Yeah. So I think attorneys, analytical skills are something that we use every day in our profession, right? And so I'm curious, tell us a little bit more about what it would take, or is it possible for an MBE or some multiple choice reiteration of it to test analytical skills? Will it require like a longer question? And is that more difficult to develop?
Yeah, it may. I have to admit, I am not an expert in development of instrumentation. I've done it over my career. But once a domain is specified, there are ways in which maybe multiple questions coming out of a similar fact pattern that attempt to get at more advanced things. But it's clear that that's not the preferred. It's not the preferred method. But I wouldn't juxtapose the notion of multiple choice format versus no multiple choice format. There are other methodologies to look at some of those more advanced assessments. So what were you thinking, Neil? Why would you want to do that?
Well, only because of the pro that in that it's easier to grade, faster to grade, right? And if that could be combined with a test that tests the analytical skills of the applicant. So I'm trying to combine.
Yeah, which is, I think, the holy grail. And that's, again, why, everybody would love to do it. Mm-hmm. I would probably have to pose that question to some of the test construction people.
Mm-hmm. Okay.
Thank you. And Alex?
Thanks, Mr. Bowles. This is a fantastic presentation.
Thank you.
I have a couple of questions for you. And I'm going to start with a very obvious question, which is, since the contents of the MBE is determined by NCBE, am I correct that the MBE is jurisdictional independent, such that the multiple choices do not test any knowledge on California specific law and principles?
To the best of my knowledge, again, you'd have to direct that question to the national conference. I've got fairly good relationships with most of at least the psychometricians there. Mm-hmm. But I would suggest that if you have, these specific levels, you could possibly get an NCBE rep there.
To your knowledge, has there been any study performed on how that impacts the overall and let's just assume for a second that it does not test California specific law. Do you know whether there has been any study performed on how that impacts the overall competency of lawyers practicing in California?
No, I mean, that would require, obviously, some experimental research, and to the best of my knowledge, that hasn't been done. You know, you could imagine an administration of, you know, a multiple choice test that has California specific knowledge and administration of the MBE, and then just determine whether or not, you know, the performances would be comparable or not, how well they would rank order the students or the applicants. Because remember, we're making pass-fail decisions off of a score. So to the degree to which the California specific questions would rank order the same as you know, a broader national based laws, if the correlations were high, you could imagine like a 0.8 or 0.7. I don't know enough about the law to say whether or not knowledge in a national setting versus California, you'd expect brighter students to respond differently on the respective tests. Or to perform differently.
In your expert opinion, if the committee were to consider eliminating MBE, do you think it would be helpful to perform some kind of study on how eliminating this MBE would impact the competency?
Oh, yeah. I mean, I try to maintain some objectivity here in doing this. I think back to the early 80s when it took us over 3 years of heavy experimentation to arrive at the examination the way it's configured now. I mean, part of that, out of that research came the performance task. When we determined that there were unique skills measured in the performance task, not only from a content perspective, but also from scores, the scores themselves. We saw quite a range of differences in the performances on these respective tests. And the reason why the performance test was even considered was because there was the same concerns about a multiple choice test back then as there is right now.
It makes sense. I just have one follow-up question.
Yep.
Relinquish the mic. In one of your slides, it says a shorter MBE would still offer a fairly high level of reliability. Can you just give us some information on that study and the number of questions that could potentially or theoretically be cut down?
Yeah. And again, I'm going on record by saying I'm not proposing that be done.
Understand, but I just want to.
Yeah, what came out of when and Amy knows this story very well, what came out of during the deliberations of what was going to happen during the pandemic, and how everybody recognized that we needed something, and we were trying to figure out how we were going to do that. The national conference offered a test to the states, but that test was only going to include 100 items, and they were supposedly randomly generated items, and they were going to cover the same content areas, but it was going to be cut in half. So there's only 100 as opposed to as opposed to 175. And so there are some psychometric formulas that were developed a long time ago to estimate what the reliability would be on a instrument of some different length. Could be half the length, twice the length, whatever. And we used as a starting point what the historic reliability levels were. And we came up with some estimates that were still quite high, not to the same level, but still quite high. Then what subsequently happened was I was called upon last year to work with a lot of the states that were basically UBE states, because they were kind of left in the lurch as to how they were going to score their examination. So I was given access to all of the individual answers on that 100-item test from about 15 to 20 states, I forgot now. And I was able to go through and do my own estimates of reliabilities on those examinations. And it came amazingly close to what the formulas predicted they would be, and they were quite high. So it was borne out by both formula and actual results. But again, now the question is, would that examination have the same level of validity because it's not covering as much of the areas as a 200-item test or 175-item test? You know, I can't comment on that.
Understood. And thank you so much for your opinion.
Yes, thank you for the thought-provoking discussion and presentation as well as the comments. Next, we'll proceed to the presentation regarding the CAPA work group analysis by Dr. Henderson, Jackie Gardina, and Judge Reeser.
Thank you very, very much. I'll be happy to share my screen with you and we have a slide deck for this. The first part of the presentation deals with, so let me provide a little context. We conducted the practice analysis study in California in the context of a larger analysis in which the Supreme Court wanted to investigate the causes of changes that were being observed in the performance of California candidates on the test. Practice analysis is a really critical component of such an investigation because it is the means by which a testing entity like the State Bar of California is able to demonstrate that the content framework for a test bears a strong relationship to practice at the entry level. And so practice analysis is a means of ensuring that the content validity of the test and questions related to the content validity of the test can be addressed in a meaningful and reliable way. The focus of the practice analysis is at entry to a profession when a test is being used for the purpose of licensure. The definition that is given in this slide is drawn from what's now an old reference, but it's a seminal one in the realm of licensure testing. And so that's the reason we chose to present that here. So with the purpose of the practice analysis being to develop a framework for determining the relationship of a test to practice, then we organized the study with two groups: the working group, which Judge Reeser and Dean Gardina were both members of, along with a dozen or so other folks. And they provided strategic leadership for the study. The other important group that was important, that we relied on in the study, was a practice analysis panel. That group is the entity that developed under my direction in a several-day period at the State Bar's headquarters in San Francisco an outline that would be assessed in the practice analysis. That outline was to address particular things that attorneys are expected to do and to know in their practice. So those things that they're expected to do, areas of responsibility, are the major duties that they have. And within them are statements of competency. So the outline, in that section of the outline, focuses on areas of responsibility and then competencies within each area of responsibility. More specifically, task statements for the competencies detail a specific statement of work that the attorney might do in addressing the competency. The second large area of the outline developed by the practice analysis panel was a list of legal topics, major subject areas in law that newly licensed attorneys might be expected to have knowledge of and to draw on in their practice. For each legal topic, there were subtopics that are just more specific statements there. It was an intense effort by the practice analysis panel to develop this outline of areas of responsibility and legal topics. The group was really diverse, was very talented, and worked really hard. But so I'm getting ahead of myself. I'll back off of that and share with you exactly what the 4 areas of responsibility were in the, or are in the that first section of the outline. So the first area of responsibility is establishing and maintaining relationships, and competencies within that provide a little more detail. The second area of responsibility is around managing the practice and administration. And so the competencies there go into a little more detail as well. Factual and legal analysis, and then resolutions. So that is a high-level view of the 4 areas of responsibilities and the 13 competencies that detail those 4 areas of responsibility. The legal topics section of the outline developed 19 different statements, and those are listed here. And so they cover some foundational topics. They cover some areas of information that are in frequent use, but then also some that might be considered more advanced, but that still could pertain to the work of a newly licensed attorney. So with this outline developed by the practice analysis panel, as talented as that group was and knowledgeable, they represented only a small portion of attorneys in California. Furthermore, there were some people in that panel that had pretty advanced qualifications, though it did also include people who were in the first several years of their practice. Even though it was diverse along critical dimensions, and even though it was an extremely talented group, and it was really important for us to validate this outline of areas of responsibilities and legal topics and the detail for each of those with data that would be collected across the state with a survey. And so the idea behind the survey was that we would ask attorneys to look at the tasks and use rating scales to evaluate them, roll those up into competencies and those up into the areas of responsibility. Likewise, for the legal topics, the idea was that we would ask the participants in the survey to use rating scales to evaluate the subtopics and then the topic as a whole. The rating scales were selected because because of their pertinence to the licensure mission. We want to know if something is, if what we're trying to do is to demonstrate the relationship between an area of responsibility or competency to the practice of an entry-level attorney, then we want to know how often attorneys use or perform that area of responsibility or use that legal topic. We also want to know if an attorney lacks proficiency or knowledge or skill in performing a particular task or competency, that there is some potential for harm. The idea of licensure being that we want to do no harm. We want practitioners to do no harm. And then performance expectation, is this a task or a competency or a legal topic that should be expected of entry-level attorneys? Or is it something that we expect only more experienced attorneys to know? I neglected to add a fourth scale here that we used in one of the surveys that asked about the depth of knowledge that would be required of attorneys in that legal topic. And I guess at this point, I need to introduce the idea that we did use two distinct survey methodologies. One's a very traditional survey where we asked participants to apply those rating scales to the different tasks and competencies and areas of responsibility and subtopics and legal topics. It's a survey that took probably about an hour for participants to complete. They were given a 1 hour CLE credit if they completed the survey. Because the survey was so long, we feel like we did well in getting people to participate in it. There are, I think, about 190,000 attorneys that were in the database eligible to participate in the survey. And so that was divided into 3 different groups. It was serendipitous that the NCBE practice analysis study was collecting data at the same time that we were in California. And so that group of 190 individuals was divided into 3, and 1/3 were given to NCBE to participate in, to be invited to participate in the national study. 1/3 participated in the traditional survey for the State Bar of California. And then the other survey method that we used is the experience sampling method survey. It's a different kind of survey. And the way that worked for the 63,000 people who were invited to participate in it was that they completed a short demographic survey initially, and then on a daily basis over the data collection period, they were sent a ping. And with that ping, they specified a time of the day, and the attorney had to select the task that was being performed at that time, and then to identify what level of knowledge would be required to perform that task, and if it was appropriate for entry-level attorneys to need to do that. Also, how what potential for harm, your criticality scale was used for that as well. That survey gave a direct measure of frequency, and that when the data were collected from all 18% of the respondents,
about the mulch.
They
I've been
working here.
No, I know, just a couple of minutes ago.
Someone is on, if you could mute your microphone, please. Thank you.
I worried that perhaps there was a transmission issue from my location to you.
No, I don't have any.
I hope that that's not the case.
Okay.
I'm not sure if there's a way to,
That's across the street.
there's a way to identify where that's coming from and mute the microphone.
It's Dr. Bolus.
I don't know. Let's go look at it.
Dr.
I
Bolus?
think a meeting host can also mute. Okay, there we go.
Thank you. I'm sorry
Great,
about that.
thank you very much. So the experience sampling method had a response rate roughly double that of the traditional survey, but it didn't take anywhere close to the amount of time. And perhaps the novelty of the survey method was a factor in that as well. We had just over 11,000 people complete that survey. And so there were differences in the method used to collect the validation evidence for the areas of responsibilities, competencies, tasks, and legal topics and subtopics. And so, you know, there's the potential for artifacts to develop related to the survey method. Indeed, we did find, while there was huge convergence, that you know, some scales performed a little differently. In particular, the frequency scale for the ESM here, experience sampling method survey, as I indicated, was what were you doing at 2:45 today? And they chose the task that they were doing. So that's a direct measure of how often a task was performed. In comparison with the traditional survey, respondents were asked to consider the previous year and how often they performed that task in that previous year. The results then can't be directly compared frequency to frequency because of that difference in methodology. Both were asked the same criticality scale, but you know, there's a potential for difference there. And in fact, we did see some findings that indicated that the number of years that an attorney had practiced affected perceptions about the criticality of the activity or the knowledge area as well. So we wanted to use the data from both methods. And so to do that, we computed a composite of which drew on the frequency ratings from the ESM survey and the criticality ratings from the traditional survey, scaling them so that they could be combined and into this composite that you see. And so given the 13 competencies, again, these are the elements of an area of responsibility, but they have been ranked here according to how frequently they're performed and what degree of criticality might be associated with them, so that those things that are performed most frequently and were given high criticality ratings appear at the top of the list and farther down. So we can see that drafting and writing is right up there at the very top of the list, and things related to establishing client relationships and practice management and supervision and collaboration were perceived as having less criticality, and they were performed less often. So that's the ranked list of competencies. The legal topics, similarly, using the frequency data from the ESM survey and the criticality data from the traditional survey, standardizing those and creating the composite. We can see that the legal topic that was drawn on the most frequently and had the highest criticality is civil procedure, and the list goes down so that tax, securities, and secured transactions were done less frequently. Now, that's not to say that they line up exactly along the frequency and criticality scales. Frequency could outweigh the criticality in this composite because of the way they were combined. But in general, this is the listing in the order that the results gave us. So this was then resulted with 2 surveys collecting data from thousands of people each. We had an enormous amount of information that the working group reduced down to some more reasonable length. And I think Dean Gardina is prepared to talk I can talk about that process. But I think that Dean Gardina will be able to give much more nuanced explanation about it, since I am not an attorney, just a psychometrician. So Dean Gardina, would you like to take the mic?
Oh, certainly, Dr. Henderson, thank you. And I think where I'm going to focus is really on those legal topics, because if you look at the CAPA report itself, you're going to see that those legal topics do not follow in the order of ranking as it was determined by the manner that Dr. Henderson just described. But there were certain topics where the working group believed that were covered in other areas. For example, employment law and family law were ranked high in that composite score, but aren't included in this final list, in part because, for example, family law is a specialization. Oh, could you go back to the previous slide, please? Could you return to the previous, there, thank you. No, the previous slide, the one that.
My computer's having a little bit of a freak out, so I'm trying to get back to the proper slide. 1 second.
Oh, okay.
Here we go.
Thank you. All right. So family law was obviously, or is, a specialization within California. So it was deemed that that was something that could be handled through the specialization, or there might be specific things related to employment law or family law that can be handled on a CLE or other post licensing or even pre-licensing manner that didn't need to be included within the exam itself. You could see constitutional law and real property actually were not ranked as high as family law and employment law, but the working group really believed that they were so foundational, constitutional law, obviously, to our system of government and much of what attorneys do, both within their practice, even if they're not specifically working in the constitutional law area, but certainly in their broader role within our society. And real property was deemed to be one of those foundational types of subjects that really weave itself through much of other areas of law. So the working group ultimately decided, one, to reduce the number of subjects that were tested and to go outside of a strict ranking and choose ones that they felt were essential to to test in terms of competency for an entry-level attorney. Dr. Henderson, is there anything that you want to provide in terms of other information related to both the competency and the legal topic?
I don't think so. I would like to augment what you said a little bit about the judgment that the task that the working group used in doing this. The data collected in the surveys provided evidence of the amount of support that could be found for use of the area of responsibility or competency or legal topic in the practice of law. But that's a different question from what should be tested and how, as long as those things that are listed to be tested are grounded in the practice analysis, and there's evidence that they are required for practice. And so I encouraged the group to exercise judgment to make sure that those things that to avoid a blind reliance on the survey data, I guess is the bottom line. It was a group of very well-informed individuals, and their background could be used to create a synthesis that the survey data itself might not be able to do.
Thank you, Dr. Harrison. And Judge Reeser and Emily were both on the CAPA working group as well. And I certainly would invite them to offer any insights they have about the kind of conversations or decisions that the working group made in these final recommendations.
There was a lot of discussion.
Yes, and it was Dr. Henderson's first time working with attorneys, so he came back, and I'm not sure what that says about Dr. Henderson, but certainly he was privy to the art of persuasion within attorney speak. So there was a lot of discussion among the working group, and Dr. Henderson, we were working off data-driven decisions, but informed by judgment, as he described. So I think the next piece is really to discuss where we started, which is that the NCBE and the state bar were both going through the practice analysis process at the same time. And so there was coordination, as Dr. Henderson described, between what the NCBE was doing and what the state bar was doing. And so what I'm going to talk about next, and I want to give a caveat to it, is really what is described as phase 2 of the NCBE's work. So for those of you who have been paying attention, the NCBE is going through its own analysis about the Uniform Bar Exam. We're going to receive an entire report on where they ended up and the future of the UBE. What I'm going to describe next is a very brief overview of just phase 2, which was their own practice analysis on a national scale, and as it compares to what we found in California. So if you could go to the next slide. So I wanted to start with the respondents, because one of the questions that the CAPA working group had for Dr. Henderson when we did finally receive the final report was, did we have a representative sample? Was this going to be sufficient for us to really feel confident about the decisions we were making? And as you can see, the NCBE got around 15,000 on a national scale, which included 63,000 attorneys that were surveyed through our database. And the California standalone one received over 1,600 or 16,000 responses. And I should note that the data we got out of the ESM actually was about 74,000 or 75,000 data points, because they took it more than once. So it wasn't that they just responded to the ESM once, but they actually received that ESM over a period of weeks. So we received multiple data points from attorneys using the ESM. If you haven't taken a look at the NCBE study or the CAPA study related to the content analysis, everything that I'm going to describe is contained directly in there. So both the CAPA report and the NCBE report did compare the results of the two surveys, and they did it slightly differently. So I'm going to show some slides from each. There were differences in how the two surveys were constructed, how the questions were asked, and the identified legal knowledge areas and the identified task areas. So there were differences between the two surveys that are important to note. And one is the CAPA questions were organized into two major categories that Dr. Henderson described, one being tasks that attorneys perform and the knowledge areas and skills required to perform those tasks. So kind of divided into those two categories. In contrast, NCBE survey consisted of 4 domains: task, knowledge areas, and then skills, abilities, and other characteristics, its own category, and then a 4th dimension related to technology. So while the two reports didn't converge in some areas, or did converge in some areas that I'll describe, they also had some notable differences. So if you could go to the next slide. So this comes directly from the NCBE phase 2 report. So not the final report and the recommendations they made, but just the phase 2 report related to the job analysis study. So you can see on the NCBE side what they identified in terms of ranking of potential knowledge areas. And then you can see on the CAPA side a comparison of our same ranking minus the things that didn't match. So you can see, you'll see legal research for CAPA show up later in our task, or excuse me, our skills. But you can see here that there's specific things that were ranked quite high in the NCBE knowledge domains that didn't show up in our CAPA survey at all. They weren't things that were identified or surveyed on. But if you go to the next slide, and again, this is taken directly from the CAPA report, and this is table 8. So you can find this yourself. I inserted the highlighted sections because the highlighted sections identified those knowledge areas that the CAPA working group actually recommended as testing subjects. We identified 8. You'll notice that there are 9 highlighted here. The 9 that are highlighted is because the NCBE job analysis study actually separated out criminal law from criminal procedure. You'll see that that's ranked 7 in the CAPA report. So it was combined for purposes of the CAPA analysis. So you can see that we're not too far off in terms of ranking. Some of them are closely aligned. The biggest difference, I think, is the administrative law and regulatory practice on the CAPA side, which was ranked number 9, and is something that the working group actually recommended be tested in California. You can see that at the NCBE ranking, it's quite low at 32. Otherwise, you can see fairly good alignment between those we chose and the ones ranked. So if you look at the next slide, you're going to see the task comparisons. And again, this is just in phase 2 report. It could be that we'll hear in our next presentation that they came down with slightly different tasks once they looked at all of the material they had in their 3 phases. But again, you could see on the CAPA side, consistent with what Dr. Henderson reported, the ranking of what the CAPA working group and the data showed were strong tasks that were required. I think what you'll notice on the NCBE side is they actually have 3 tasks specifically related to research, while we have 1. Again, that is a function of the difference in how the 2 surveys categorize things. They actually separated out on the NCBE side different types of research tasks, whereas we collapsed research of laws and precedent into just 1. So there is quite a bit of alignment on the research side, as well as I think on that writing, editing, and drafting, among other types of tasks, although stated slightly differently. Again, I would invite Judge Reeser or Emily to comment on anything else that they would think has been left off of this quick comparison.
Thanks, Jackie. I think this is great. This is all what I would absolutely agree with. I would just point out 2 things. One is, in case you're wondering, professional responsibility is certainly something that we thought very highly of, and as did the NCBE, but I think both NCBE and CAPA felt that it could be tested outside of a traditional bar exam setting like it is now with the MPRE, so that's why it was eliminated. And then the other thing I'll just say is that, and I'm sure that in our next session this might be coming up, so forgive me, but I believe that the NCBE within their civil procedure context have included how proceedings before administrative agencies might work. So while we do have administrative law and NCBE doesn't, there may be some crossover there within civil procedure. Thanks.
Thank you, Emily. And so again, this is just the phase 2 report comparison. Obviously the NCBE had multiple phases and ultimately came down with final recommendations that I think we're going to hear about in the next hour. So you could go to the next slide. And Amy, I don't know whether or not this was, I know that you had identified this slide specifically. If there's anything that you want to finish up with here.
So actually, Jackie, this slide was assigned to me. So,
oh, sorry.
Right. So you were given all these slides to address, and I'm given 3 bullet points, which is perfect. So Dr. Henderson and Dean Gardina, thank you for that. That was very articulate and comprehensive, but it did describe the work that the CAPA group did. And so there was actual science, and I think that the scientists call it psychometrics. Is that right, Dr. Henderson? Psychometrics to the practice of law. So what was fascinating about this process, if you were not on the committee, is that this is what lawyers are actually doing, right? What is everybody doing from day to day? Because our core topics in law are borrowed from, from the common law and from the 18th century. So the question is, are these topics current? And is this what people are doing? And to a large degree it is, but to a certain degree it isn't. And so this was really helpful to this committee in figuring out, does the bar exam test for what people are doing in the first few years, and what tasks are critical for them to perform during that period within those disciplines, right? So this was the committee's way of pulling that together and making recommendations. And they, I watched both within and from without, and they did a fabulous job. But as I sat on this committee, there was all these things banging around in my head the entire time I was attending these meetings, because even though we were studying what should be tested for, there were certain questions that really weren't answered, and that is, should we be testing for them at all? Or how should we be testing for them? One of the issues as a judge that I encountered frequently was I had a lot of lawyers over the course of decades who came into court, admitted what they call pro hac vice, which is they're not California lawyers, but they come in from other jurisdictions because California doesn't have reciprocity unless you sit down and take an attorney bar exam. And every time one of those lawyers came into my court, and it was not infrequently, every one of them was competent. You know, I never thought, gosh, I wonder what their cut score was on their, you know, the Indiana bar exam or whatever, right? They were all competent. And it occurred to me, you know, not just as on this committee, but over the course of time, that perhaps one reason we don't allow reciprocity is because we're effectively, the state bar is effectively a trade guild for which competition is sort of an anathema. But it occurs to me that there's so many negatives about reciprocity and so many positives about allowing competent lawyers. I mean, let's say a lawyer has, you know, 5, 6, 7 years of practice or more in a different jurisdiction, and there's no ethical complaints about them. Why would we not welcome them, you know, as California lawyers? Why do we make them sit down and take a test? The other states don't do it. I mean, if you're in New York and you want to practice in Illinois, I think what do they charge? Like $500, $750. They do a, you know, a background check and they're in, right? So that was banging around in my head as we were thinking about why, you know, testing. The other thing, one of the other things is that people think different ways, right? Brains work differently. Everybody is an individual and everybody's brain functions differently. So for example, you know, my own case, you know, I have what I told Amy last week was, you know, a case of serious trivia head, right? I have all this trivia in my brain. And so when I was in law school, you know, decades ago, I had probably 24 classes and only 2 of them were multiple choice. And of course, you know, my brain working the way it does, I got the highest score at only 2 classes in law school. And it turned out to be the exact same 2. There was a multiple choice test. So, and in the other classes, of course, I didn't get the highest score because, you know, I wasn't the best student. But having said that, taking a bar exam that was so weighted so heavily on multiple choice, you know, that clearly carried me through the exam where, you know, I was at the end of the bell curve, presumably, and perhaps my essays were at the other end, but I became a lawyer. But none of it, to me, has anything to do with, you know, how good you are as an attorney, right? Because being able to take a test, especially under those tense conditions, doesn't necessarily correlate, at least in my mind, to being a good and competent lawyer. It's just a test, and it's a very artificial circumstance. So in addition to people having different brain functionality, people react differently under stressful situations, right? There are people who cannot perform at all circumstances. I mean, here are people who've devoted years of their life, in some cases going to law school at night, working during the day, supporting their families, and all this pressure is on them to perform exceptionally well over the course of what is now 2 days, and they can't do it. They can't deal with that situation. As a lawyer, we don't take tests, right? We don't take 2-day tests. So it's while the bar exam is a good exemplar of how you will take tests, it doesn't necessarily correlate to people being good lawyers. There are folks who, let's say they're non-native English speakers, who want to work in communities that are underprivileged or they're marginalized, and their whole goal is to serve those communities. And yet they can't reach our cut score, and our communities are deprived of those lawyers. And so I think about these people spending years of their life effectively wasted, if you will, taking bar exam after bar exam, missing the cut score, and missing our opportunity to envelop those people into our legal community, because actually they are good lawyers and they will be good lawyers, but they just, whether it's their brain functioning, whether it's the nativity of their language, whether it is their ability to exist under stressful situations. I mean, all those factors to me question whether in every circumstance we want people taking the bar exam. So that was banging around in my head as I was listening to the psychometrics. You know, I'm an old guy, right? So for those folks my age who didn't want to go to Vietnam, they got to join the Peace Corps. So if somebody is dedicated to working in one of those underserved communities, and they want to work 3, 4, 5 years in those communities, it does a service for us, it does a service for the state. Why would we not just welcome them into the legal community as opposed to saying, no, you're going to sit down and you're going to take this pressure test for 2 days or however long it's going to be using these criteria. So to me, I love being on this committee, but it didn't ultimately answer the question of should we have a bar exam? What should we test for? Should we allow people the opportunity to work around the bar exam and other potential options? So alternative licensing pathways, reciprocity, I think those are all in the game. I'd like, at least from my own perspective, have them reconsidered and be a little more fluid in how we look at our trade guild and allowing the state citizens to be served. And at the same time, I get it, protecting the public, but I think we ought not to fall into the trap of saying, unless you hit our cut score, we're not protecting the public. Those are my thoughts.
Thank you very much to all of the presenters and for summarizing your work as part of CAPA and also your very helpful thoughts on these important issues. We've gone over the time for lunch, so I apologize. I thought in order to make up the time or some of it, if we could just take a 10-minute break and then have a working lunch, if you could grab something to eat, or I'm sorry if that doesn't work. I understand if some of you may need to take some time and have your microphones or your videos off, but I think we're able to make up some of the time later. And so at this point, we'll take a recess for about 10 minutes and reconvene at 1:30. Thank you. Good afternoon, everybody. We're back in session with the meeting of the Blue Ribbon Commission. Next, I would like to invite the Honorable Cindy Martin, who's the Chief Judge with the Missouri Court of Appeals. She was appointed to the Court of Appeals in October 2009, and prior to her appointment, she was in private practice for about 25 years, emphasizing commercial litigation, general business representation, public law representation, and business and real estate transactions. And I'll turn it over to Judge Martin to say a few words if she would like about her background and to talk to us about the future direction of the uniform bar examination. Thank you very much.
Thank you very much. I really appreciate the opportunity to visit with all of you and appreciate the kind introduction. I think it really belies kind of the answer to a question of why me? Why someone who's sitting on a court in Missouri to talk with you about the future direction of the UBE and the next generation of the bar exam? Because I'm much like all of you. I'm a volunteer with a strong passion for bar admissions and bar admission issues and for matters that impact our practice and the admission of those to the practice of law, securing that general license to practice. And in some ways, I think there's great value actually to being in a position where as a volunteer, I've had the luxury and the honor, frankly, of serving for 11 years on the Missouri Board of Law Examiners before becoming involved as a volunteer on the National Conference of Bar Examiners, as a member of the Board of Trustees. And in that context, to gain quite an education on the value of the products and the services that the conference provides, the integrity with which those products and services are developed and maintained, and the amazing collaboration that the conference enjoys with the jurisdictions it serves. They listen quite well and work very well with the jurisdictions to be in a position to provide the services that are essential to each jurisdiction, which, as you know, makes its own independent determinations about the credentials that would be required to secure a license in that jurisdiction. And in that context, working as a member of the board, I was very honored to be asked to chair the testing task force, which I'll speak a bit more about in a minute, and then the implementation steering committee, which now has been charged with implementation of the recommendations that came out of the testing task force. And that context, I suppose, makes me somewhat of an expert or not, I'm not sure what, but certainly an impassioned individual, very happy to have this chance to speak with you about what the conference's next generation bar exam will look like, what it will do, and what it could provide California to the extent it's something of interest to your jurisdiction. It kind of creates a great foundational starting point. And I think it's not an easy question to answer. And that is this notion of why a bar exam? What is the purpose of a bar exam? From the conference's perspective, that is a question that's steeped in policy. And it's really one that has to be answered by each jurisdiction. But as the primary provider of bar examination materials, we feel confident that the purpose for a bar exam, if utilized as a part of the credentialing model, needs to be to assess whether an applicant possesses the minimum knowledge and skills that can be fairly expected of that applicant as a newly licensed lawyer, securing a general license to practice law for the purpose of public protection. And there are a couple of really key components that I want to highlight there. Number one, I think we all recognize that the practice of law is really very different than many other licensed professions because the license you secure is a general one. And once that license is secured, there's very little regulation that goes into how you utilize that license. And so to the extent a bar examination is that last vestige of the credentialing model, it seems advisable that a bar examination should be focusing on assessing the foundational concepts and principles and skills that a general law license would require. In other words, that would transcend practice areas, and that would be thus fair for whomever is getting the license, regardless how they intend to employ it. The other thing that I think is important to keep in mind is that the bar exam is not the end all and the be all for any jurisdiction's credentialing model. It is one important piece. It is a part of the ecosystem at bar admissions, and that collaborative relationship beginning from the point of legal education through the point of completion of law school successfully, to bar exam passage, character and fitness, the multi-state professional responsibility exam, and any and all other credentialing requirements that may be imposed by a jurisdiction. All of that creates a package. And it should be a package that as a jurisdiction, you can take a look at and feel comfortable. You're sending a message that once that all important decision to bestow a license is made, with all of those component features taken into consideration, that you have in fact taken a look at public protection as your primary bellwether and fundamental fairness to applicants as a part of that process. And so if we could go to the next slide, please. One of the things the conference undertook as a part of best practices in high stakes licensure exams is to look at a testing task force, and we formed that testing task force in January of 2018, fully intending it to be a 3-year long research project that would empirically and with an unencumbered look at the bar examination, look at content, format and structure, delivery method, and timing of the bar examination. This was not the first time that NCBE had undertaken a content validity study. It did so in 2012, and previous studies had been undertaken as well. But this was the first time that we did more, frankly, than what best practices would have required. When I'm speaking of best practices, I'm referring, of course, to the Bible, the standards for high stakes licensure examinations that are set forth in the standards for educational and psychological testing. They recommend that you do a periodic assessment of the content validity of your high stakes licensure exam. But the TTF didn't want to stop there. We wanted to look at the bar examination as a whole, and we saw a genuine opportunity to collaborate with stakeholders on that continuum in the bar admissions arena. And that is why we undertook a broader scope for this research than simply to look at content. The scope exceeded best practices, and we used a 3-phase research project to do so. We listened through very significant and important listening sessions to the good, the bad, the blue sky. What was it that people liked about, didn't like about, wanted to see in a bar examination of the future? The second phase was a very sophisticated practice analysis